Next up, we've got Mark talking about disclosure.
Good morning. I'm Mark Chesher. I'm a managing associate in the London office, and by virtue of the fact that I've been involved with e-disclosure in particular for the last 8-9 years, I'm one of our super users, as we term it, for disclosure, and generally thought of to be our sort of one of our disclosure gurus. I'm going to pick up the theme that's been running through these talks of preparation and planning. We've already spoken about the lockdown of documents, but if you're now at the sort of disclosure stage, you're obviously looking to pursue litigation. And actually, if potential recovery of the assets and litigation is one of the potential objectives at the outset of your investigation in your first 24 hours, then you need to think very carefully to preserve the forensic integrity of data. Where you've got an employee fraud in particular, it's very tempting to see their laptop there on the desk and think, I want to have a look at that, I want to open it up, switch it on and have a look, see what he's been up to, or she. That's pretty much the worst thing you can do, because as soon as you turn it on, you lose some of the forensic integrity of that data that's on that system. What's much better to do is get in an expert, get that get the laptop imaged and forensically dealt with before anything happens to it. Then you've got an exact copy of what was on that system at that time. And it may be that later on down that line, that expert witness in 2 years' time, maybe when it gets to court, is an absolutely vital witness in proving the case. And the information that you preserve by taking that step has actually won you the case. The other aspect, as soon as litigation is contemplated, there is a positive duty on you to preserve documents. That goes beyond sort of the fact that it's obviously sensible to do so. You're actually under a positive duty now, and you could be penalised by the court if you fail to adequately preserve documentation. One aspect in which you can be penalised is in costs, but actually more relevant probably to fraud cases is that the court can draw adverse inferences if documents have been destroyed. And the adverse inference that the court might draw is that those documents were destroyed deliberately because they were unhelpful. Just moving on forwards. There's two sort of main objectives when you're looking at disclosure. First of all is to assist the investigation. As soon as things move into a more contentious sphere, you've got more weapons at your disposal, and I'll come to those in a bit. The other thing is you've obviously got to find the evidence to prove your case. Now, if you start planning early and you're clear about what your objectives are, you need to start thinking about what you've got to do throughout the life of the case in terms of documents and what challenges you might face from the way that things are set up in your business. And that goes from, it touches on every aspect from pleadings to trial to enforcement. You don't necessarily need to have an answer to every question and every issue at the first stage, but you need to at least know what the potential challenges are and have them on your list and get thinking about them, prioritising the ones that are absolutely key. Certain things to think about, obviously in our scenario we've got at least two jurisdictions involved, and we've touched on different attitudes to the different legal regimes and the difference between the civil regimes and common law regimes. One particular feature of civil regimes is that they don't really understand our concept of disclosure, and they don't necessarily understand the need to preserve documents. And so, it can be it's really important to get across to people in those jurisdictions that you need to preserve the documents and that those documents are going to have to be dealt with. Multiple locations, multiple jurisdictions, you're also going to have data protection issues and potential data security issues. For example, if you've got a load of documents in Qatar, do you want to bring all of those documents over to the UK within the jurisdiction to then go through all of those documents to see what's relevant? Or are you actually better off doing the document review in Qatar and then only bringing across the documents you actually need and will be disclosing? We've touched on the need to investigate all the sources, servers, looking at documents on the cloud, laptops, Blackberries, iPhones, iPads, etc. What languages are you looking at? Obviously with Qatar we're looking at Arabic. How are you going to deal with Arabic speakers? How are you going to review Arabic documents? Very quickly, some of the weapons you get when you move into the sort of contentious litigation sphere, you get potential pre-action disclosure, Norwich Pharmaco application, which Ian has touched on, and you might have seized documents from a search and seizure order, or indeed disclosure from a pursuant to a freezing order. You need to think about the evidence that you're going to need to win the case, and it might be beyond the usual paper trail. You might want to look for evidence of tampering with documents, deleting documents, falsifying documents. All of that's going to be good evidence to help you prove your case. In this situation, as John mentioned, one of the potential scenarios that the fraudsters might come up with as a defence is actually, you authorised me to make these bribes, you told me to make these bribes, and I've taken, that's where the money's gone. You might want to then pin the defendants down to exactly when and where those meetings took place, or if it was telephone conversations or documents, where did they get that authorisation from? And the more you can narrow it down and pin them down to exact times and dates that they were authorised, presumably it would be in a face-to-face meeting, or maybe on a phone call. If you can pin it down to actually prove that the two individuals they say had a meeting were never in the same country, or weren't in the same country at the time, you can deal with that defence. We're looking at a new regime now, post 1st of April, and I'll deal with it very quickly. But the entire the overriding objective now has now changed, and is now an override is to ensure that the courts deal with cases justly and at proportionate cost. Cost has really come into the equation, even with major fraud cases. One aspect of disclosure that you might want to look at as a claimant in a fraud action is train of inquiry disclosure. CPR 31.5 now replaces the old concept of standard disclosure as the default position, and you've now got this menu of options to choose. Very, very briefly, one of the aspects of the pressure on costs and reducing costs of disclosure is reducing the number of documents disclosed, but it's also reducing the amount of sort of satellite litigation that goes on in relation to disclosure, and disclosure applications, specific disclosure applications, are going to be discouraged. But having said that, there's going to be it looks like there's a really high bar now for obtaining train of inquiry disclosure. We tried it in the Berezovsky-Abramovich case, seeking to get Abramovich to give more sort of enhanced disclosure, and the court, which had in mind that Jackson reforms because they were out, the report was out. The court declined to give us train of inquiry disclosure on the basis that it wasn't proportionate. Now, this was a case with hugely well-funded individuals. We now know that Abramovich spent over £50 million on it. There was $6 billion at stake. It's hard to see a case where it would be more proportionate than in that case to give that sort of disclosure. We talked very briefly about how you investigate, how you interrogate the documents, and the same sorts of principles apply, and we would use the same tools in terms of disclosure as you would use in the investigation stage, and a lot of that data will sort of be captured at that stage and will be used later on, obviously adapting it to the issues as they've progressed. So that's all I had on disclosure. The key thing is prepare and plan.